I'm now pleased to introduce the witnesses for our second panel for today's hearing. Our first witness is Congressman Frank Pallone, Jr. of the 6th District of New Jersey. First elected to Congress on November 8, 1988, Mr. Pallone serves as a senior member of the House Energy and Commerce Committee, and in January 2007, he became the chairman of the Energy and Commerce Committee Subcommittee on Health. Mr. Pallone also serves on the House Natural Resources Committee. Additionally, Mr. Pallone authored H.R. 5086, legislation to require the Attorney General to issue guidelines regarding deferred prosecution agreements. We want to welcome you and thank you for your patience, Mr. Pallone. Our second witness is Congressman Bill Pascrell, representing the 8th District of New Jersey. Elected to Congress in November of 1996, Mr. Pascrell serves on the Ways and Means Committee and on the House Committee on Homeland Security. I want to welcome you both. I appreciate your patience in waiting until we could actually have you guys here to testify. And with that, I would invite Mr. Pallone to proceed with his testimony.
Thank you. I want to thank the subcommittee for holding this very important hearing on the process for appointing federal monitors and deferred prosecution agreements, and particularly thank the chairwoman, Linda Sanchez, for inviting me to testify today. Recently, it has come to light that certain federal prosecutors are using their powerful positions to steer no-bid contracts to former employers and other influential people with which they have close ties. And I find it troubling that federal prosecutors have such tremendous discretion in appointing these corporate monitors. Allowing an unelected official unfettered leverage against companies and corporations who have potentially engaged in criminal behavior invites the type of abuse our judicial system is designed to prevent. Specifically, in my home state of New Jersey, a consulting firm led by former Attorney General John Ashcroft received a contract from U.S. Attorney Chris Christie, his former employee. The fact that there was no competitive bidding and no public input in this process is problematic. It seems that every U.S. attorney handles the process of appointing corporate monitors differently. Some, like Christie, literally dictated the choice. Others provided a short list to the company accused of criminal activity or simply reserved the right to veto a company's selection. With little say over which firm is appointed as a corporate monitor, companies are strong-armed into complying with the will of the U.S. attorney, and this essentially amounts to corporate blackmail on the part of the U.S. attorneys, in my opinion. Yesterday, the Justice Department released an internal memo outlining a set of guidelines for the use of federal monitors in connection with deferred prosecution agreements. While it's encouraging that the Justice Department considered some of the reforms included in the legislation I've introduced, the new guidelines are far too weak. I believe that the only way to ensure that politics and favoritism are completely removed from this process is to have someone independent of the Justice Department, like a U.S. District Court judge, involved in the process. And that is why I've introduced H.R. 5086, which would establish safeguards and eliminate the culture of favoritism and political interference that permeates these corporate monitor agreements. My legislation would direct Attorney General Michael Mukasey to issue guidelines delineating when U.S. attorneys should utilize corporate monitors. While the Justice Department touches upon this in its memo, the guidelines the Department outlines still give far too much latitude to U.S. attorneys. My legislation requires that a corporate monitor be selected and approved by a third-party district court judge or other magistrate from a pool of pre-qualified firms. These monitors would then be paid according to a predetermined fee schedule set by the district court. The legislation also sets out criteria for consideration in the determination of whether to enter into deferred prosecution agreements. The Justice Department guidelines do not provide sufficient guidance as to when these agreements are appropriate. My legislation recommends that the Justice Department consider the impact an agreement will have on employees and shareholders. Additionally, the Department should consider remedial action taken by the corporation in response to wrongdoing and possible alternative punishments available. Having a uniform set of criteria available for when to enter into these agreements will be essential in eliminating abuse. Another important aspect of my bill mandates that all corporate monitors submit reports to the appropriate U.S. attorney and U.S. District Court. The Department guidelines vaguely state that, I quote, "It may be appropriate for the monitor to make periodic written reports to the government and the corporation, but this needs to be a requirement. It is essential for these monitors to keep the Department and all involved parties apprised of the progress being made on the agreement. And this will also ensure that the corporate monitor is properly performing all of the duties mandated in the agreement." And Madam Chairwoman, I would suggest to the subcommittee that the separation of powers issue is a red herring coming from the Justice Department in an effort to avoid congressional action. Mr. Nahmais said there was no problem with the court approval of the deferral, so why would the guidance as to when to defer be a problem? Why would court approval of the monitor or the other transparency provisions in my bill create any constitutional problems? I don't see them. The use of deferred prosecution agreements and corporate monitors has increased exponentially from 5 in 2003 to 35 such agreements last year. I believe that the reforms offered in my bill are essential in rooting out any possible corruption or wrongdoing in the process of distributing these monitor arrangements. We can't allow U.S. attorneys or the Justice Department to have unyielding and absolute powers in this process. And once again, I just want to thank you, Madam Chairwoman, and the subcommittee for inviting me here and Congressman Pascrell to testify. It's my hope that we can work together to have further hearings on the issues so that constructive reform to the process of deferred prosecution agreements can be brought about. Thank you.
Thank you, Mr. Pallone. We appreciate your testimony, specifically about the legislation that you have introduced. At this time, I would invite Mr. Pascrell to give his oral testimony.
I want to thank full committee chairman Conyers and subcommittee chairwoman Sanchez and ranking member Cannon for allowing me to testify today. On November the 26th of last year, I wrote to Chairman Conyers and Chairwoman Sanchez calling for hearings on this critical issue. So I appreciate how far we've come in such a short period of time. My attention was first brought to this issue of deferred prosecution agreements because of the published reports that the U.S. Attorney for the District of New Jersey, Christopher Christie, has reached a $311 million settlement to end an investigation into kickbacks being made by leading manufacturers of knee and hip replacements. The fact that Mr. Nahmais has admitted that he has no idea why Mr. Christie got prosecution of this case is exactly why this whole process needs real oversight. And if I might add, Madam Chairwoman, it's the only reason why we're here today is because Zimmer Holdings filed an SEC report. So we were in the dark up until that particular point about all of these procedures. Let's not kid ourselves. Let's cut to the chase here as to what we're talking about. This agreement raised questions about the discretion of the U.S. Attorney's Office to select federal monitors since Mr. Christie had selected Ashcroft Group Consulting Services, which according to reports stands to collect as much as $52 million in 18 months from its monitoring of Zimmer Holdings of Indiana. I'm disappointed that Mr. Christie is not appearing before this subcommittee today. Mr. Christie is at the center of this investigation and has thus far failed to enlighten members of Congress or the general public about the process by which he concluded this deferred prosecution agreement. Mr. Christie is needed in this hearing in part because he awarded a $10 million monitorship contract to a former public official that served in the Morris County Board of Freeholders, a contract that was paid by UMDNJ, a public education entity, meaning that taxpayers footed the bill. Now, I want to make it very clear that throughout this process, I have not made any accusations of corruption on the part of Mr. Christie. Indeed, in his examination of corruption in New Jersey, I have publicly and privately spoken out and applauded him for all of his efforts on a nonpartisan basis. So let's get that. Somebody said up there we're attacking him. That's absolutely absurd. There are a number of indisputable facts in this case that raise very troubling questions have yet to be answered. First and foremost is the fact that Mr. Christie selected former Attorney General John Ashcroft, his own former superior, for a highly lucrative federal monitoring contract. No conflict of interest? In addition, he selected 4 other federal monitors under this deferred prosecution agreement. In every instance, Mr. Christie selected former Justice Department associates to monitor these medical device manufacturers under highly lucrative monitoring contracts. This was seemingly done without any negotiation of fees, any consideration of selecting monitors with whom he was not closely associated with. In my mind, these monitoring agreements clearly amount to no-bid federal contracts that are ripe for political considerations. I want to be clear in saying that the selection of close associates by a federal officer to take on highly lucrative contracts, which are never negotiated and in which outside contractors are never considered, is the essence of political favoritism. I'm pleased that the former U.S. Attorney General agreed to testify before this subcommittee, as is necessary to understand the process, or lack of it, of which he was selected as the monitor for Zimmer Holdings. In the end, I'm troubled by the fact that as Attorney General, Mr. Ashcroft literally created the process of deferred prosecution agreements, a process that he now benefits from handsomely. As I delved deeper into this case involving U.S. Attorney Christie and former Attorney General Ashcroft, I came to the realization that this case of deferred prosecution agreements encompasses an even larger issue of corporate prosecutions in the post-Enron era. In researching the history, I discovered that the practice of deferred prosecution agreements was made legal through the Speedy Trial Act of 1974, and that this remedy was rarely used by government prosecutors except in small-scale drug cases involving diversion programs, usually for marijuana-related offenses. Almost 20 years later, in 1993, the Department of Justice somehow interpreted this narrow statute used for small-time crimes to now be used to fight large-scale corporate corruption. It is my contention that the legislative intent of the Speedy Trials Act of 1974 was never meant to adjudicate large corporations, and it seems clear that the Department of Justice in recent years has consistently worked to shield this practice from oversight by Congress and the courts. I myself have not yet introduced legislation on this significant issue because I believe that this issue must first be investigated by this committee. This is appropriate. In December of last year, in lieu of legislation, I sent to the committee my statement of principles on deferred prosecution agreements. These 4 principles laid out a comprehensive approach to reforming deferred prosecution agreements. I cannot, in conclusion, stress more strongly the need for comprehensive legislation to reform a deferred prosecution process that has been created by the DOJ to generate unmitigated power for federal prosecutors without the necessary oversight. There is no oversight. These deferred prosecution agreements lack any checks and balances within the system, as power is almost entirely concentrated in the hands of federal prosecutors alone. No one here, including myself, is in a position of defending corporate corruptions or arguing against their full prosecution by the law. In this instance, we are left with a deferred prosecution system that gives federal prosecutors unmitigated power to be the judge, the jury, and the sentencer. Truly, it was never the intent of our justice system to concentrate such power in the hands of the few. We must not allow deferred prosecution to become a form of deferring justice. Thank you, Madam Chairwoman.
Thank you, Mr. Pascrell, for your testimony. I want to thank this panel for their testimony, and unless we have any questions for this panel, they will be excused.
Madam Chair, I would love to question this panel.
Gentleman seeks recognition. Gentleman is recognized for 5 minutes of question.
Thank you. And we don't look to you as experts on an issue that I think is very, very important. In fact, Mr. Pascrell and I had a discussion yesterday about the importance of this issue. I would like to just I want to get some information out, and I know this is a relatively emotional issue, but as you're looking at this, both of you talked about courts reviewing the process. It seems to me that we're much better off if you have an administration process, that is DOJ, which I think you would both say is inadequate, but if that were complemented by an external review in Congress, which would probably be this committee, is that consistent with what you both are thinking about this?
Mr. Pallone.
It's not, in the sense that I am concerned that if the only review is, I should say, if the process continues to be internal within the Justice Department, and there's no court approval or court appointing of the monitor, then I do think that the potential for abuse continues. And so a hallmark.
Why are we better off with a court or various courts approving monitors as opposed to having a process internal to justice with some advances that they've recently made and a series of memos that have helped verify or helped qualify the problems? Why would you want a court or courts around the country to do it instead of having one sort of central review place like Congress?
Well, I'll answer your question in sort of a 3-step process. I don't mean to suggest that the Justice Department in putting forth something isn't moving, in a progressive way. But I do have a problem with 3 things. First of all, they don't really delineate what criteria would be looked at.
Right. In other words, I think, let me cut through. We agree that the current guidelines are not sufficient. Everybody on the prior panel agreed that they're a work in progress. We need to advance it. So
Okay, well, that- I didn't
no
realize
question.
that
But
you were
the first place you have to go is you have to have better guidelines.
Right.
But ultimately, as you develop those guidelines, as this committee oversees those guidelines, aren't we better off retaining oversight here in Congress?
Well, you
than
should
letting
have oversight, but the problem is even if you have guidelines and criteria for when you should have deferred prosecution agreements, which we have in my legislation, even if the Justice Department went that far and did that on their own, which I would hope they would, but even if they did that and they haven't, if you don't have a third, independent third party, in this case a judge or a district court judge, which is what I suggest in the legislation, then I think the potential for abuse and the conflicts that we talk about could still be out there because it's still within the Justice Department. And then you also need the transparency of, having, the courts look at the agreement, how much the person's being paid.
Given the shortness of time, I think Mr. Pascrell has something he wants to say, and then I want to pose what I think is the dilemma that this all creates. Yes.
Mr. Cannon, the first thing I would do is make sure we have full disclosure. We do not have this now.
To the world,
wasn't
or to this, or to
Sorry?
to the world, or to a judge, or to this committee? Who would you do full disclosure
Well,
to?
I incorporated in my recommendations the chief judge of the district court should be monitoring the situation every quarter. He should get a report from both the prosecutor and the company, so that somebody knows and somebody has some oversight. This committee, in no manner, shape, or form, should be minimized in that process. It is an attempt, basically, to have a checks and balance system. But you need to have full disclosure. We had no disclosure right now, and the only reason why we discussed that, I don't think I was exaggerating, using hyperbole, is because Zimmer Holdings had to file with or did file with the SEC. That's how we got to know what was going on, and the reports came out, newspapers reported it, and I was shocked to find that nobody knew what was going on. In fact, we just learned that some corporations...
Pardon me, Mr. Pascrell, I see that I only have a minute, and there's just a couple things I want to do, and I appreciate the intensity and the lack of transparency, which we really need to focus on. But let me suggest that the problem here is that we are now lambasting a lot of people's reputations. And so I'd like to submit for the record 2 articles in the Washington Times, one dated March 11th, a medical supplier striker probe, the other dated also the 11th, let's see, I think it's First Spitzer, Now Striker is the title.
Without
These things
objection,
have
so ordered.
wild allegations in them. $17 million directed, according to this article, toward Democratic candidates over the years, and that's directed at John Conyers, and quoting an aide to Nancy Pelosi, talking about you have more than an appearance of a conflict of interest. You have a conflict of interest, says leadership aide to Pelosi. In our current environment, we can't afford to have many more of these situations.
Time of the
fact
gentleman
is,
has expired.
as we continue to pound on people's public reputations, you two guys are both from New Jersey, and we're all tied into people slamming people's reputations, where I don't think, at least in the case of Mr. Ashcroft, there is a shred of evidence that he's done anything improper.
Time of the gentleman
whose
has-
reputation are we slamming?
The time of the
you've been-
the time of the gentleman has expired.
Mr. Christie's and Mr.
The
Ashcroft.
time of the gentleman has expired. I think I've been more than lenient today with time to the gentleman. Does Mr. Johnson have any questions that he would like to ask of this panel?
I'll just say that this legislation appears to be reasonable in its scope and its intent, and I think it's something that I certainly look forward to supporting. And I do appreciate the heads up given to this committee by Mr. Pascrell about the need for hearings. And my hat is off to the chair lady for calling this hearing. And I'm concerned about the outsourcing of justice in white-collar criminal cases to private industry, i.e. insiders of prosecutors, and it's a system that begs for oversight. Something else in addition to what I've heard about you do the crime, you do the time, is that there's two types of crime. One is legal crime, the other is illegal crime. The illegal crime is blue collar, and the legal crime is white collar. And society should definitely, American society, we should have full confidence in our justice system that justice is fair and is blind. And so if we have every corporation that gets in trouble being able to take advantage of a deferred prosecution agreement, and in some cases a non-prosecution agreement, and there being no oversight, no guidelines, in fact, no information about it that's available to the public. That's a disservice to the ideals that this country was built upon. And so we must consider this legislation that's been introduced. I want to thank you.
Could I?
Does the gentleman yield back?
Would the gentleman yield
Yes,
just
the
for a
gentleman.
moment?
Before I yield, I will ask Mr. Pallone to respond.
Well, I just wanted to say that I appreciate the fact that the gentleman is talking or focusing on whether and when we should even have these agreements, because I think that a lot of the focus today was on the monitor and the process, but I really think that the committee needs to focus on whether or not these agreements should even be out there and how often they should be used. And that's why in the legislation I also have criteria that would be met before they would even proceed, because I do think that there are too many of them, and that it is a problem in itself, separate and apart from the issue of the monitor and the conflict of interest and the abuses that Mr. Pascrell and I have talked about. I think that larger issue needs to be looked at.
Thank you.
Would the gentleman yield?
I'll
As
yield.
I know that Mr. Pascrell wanted to make a comment. I don't want to be offensive here. This whole hearing has largely been about Mr. Ashcroft and Mr. Christie. Their reputation has been put on the line, but I didn't want to see you cut off Mr. Pascrell, and I didn't want to make that an accusation, but we are now in the middle of a lot of reporting about things that are problematic for many people's reputations. So with that, Mr. Pascrell, I know that you wanted to comment.
Reclaiming the balance of my time and
Thank you.
asking for Mr. Pascrell's response.
I just wanted to make this very clear, again, Mr. Cannon, that I was one of the few people from my party that praised Mr. Christie's work. That does not give me a pass on what I believe is a significant area to look into and investigate. I personally believe that this committee not only has the wherewithal and the responsibility to do such. When you look at the term conflict of interest, it is at the basis of practically every corruption case. Now, there are 44 of these deferred agreements that I've looked at, so the knowledge that I have and for the information available, because in some, we have no knowledge. We have absolutely no knowledge. I think that you have a right and I have a right, the public has a right, particularly when 10 of the 44 deal with health matters and a lot of others deal with international funneling of money. I think we have a right to ask the questions, particularly at a time when we're examining Medicare fraud, because this is increasing the price and the cost of what products are sold to our senior citizens. These doctors, bribed, you use whatever term you wish, were bribed by the company to push the product. I think that's pretty serious business.
I think that's not just a right, but a responsibility that we have
Absolutely.
in this committee.
The time of the gentleman has expired, and I just would like to take my 5 minutes to thank you both for testifying today, for following with such passion the developments of these deferred prosecutions, Mr. Pallone, the thoughtfulness of your legislation. And just to pick up on a couple of things, I think the reason why this subcommittee was interested in holding this hearing is because there are a number of problems that we have identified. Number one, the discretion to use these deferred prosecution agreements, the fact that there aren't real concrete guidelines as to when they're used and who's making the decision and why are certain corporations allowed to enter these and others are prosecuted criminally, I think certainly is the first step in the analysis that needs to be thoroughly done. I think once deferred prosecutions are entered into, how the monitor is selected is a very relevant question for this committee to ask. And I think that we need to look to potential solutions that would take away any conflicts of interest or potential conflicts of interest that might exist. Now, I know Mr. Delahunt was particularly concerned with the fact that corporations sometimes in these deferred prosecution agreements get to choose who they want to have monitoring them, and I think we heard from our first panel of witnesses, all experts or have familiarity of these deferred prosecution agreements, that whoever is selected needs to meet some basic criteria and needs to have not just a well-established knowledge in the area of law in which these corporations have fallen short, but also an understanding of how some of these businesses run so that they can do their job effectively. And I don't think that it would harm the system to have some kind of entity that can oversee the monitors, because right now it doesn't appear that anybody is monitoring the monitors. There was some debate as to who does the monitor owe a duty to. Is it the corporation? Is it the shareholders? Is it the U.S. government? Is it the taxpayer? I mean, it seems like there are some of these conflicting ideas about to whom the monitor owes a duty to do their job, and the fact that there isn't the kind of oversight available to go back and look at, how are they billing the corporation for their time? What exactly are they doing to receive, in some cases, some very lucrative contracts? And I'm not suggesting that the fees are wildly inappropriate, depending on whether or not there's been adequate work that justifies those fees. And I don't think it's asking a lot to require some detailed billing statements. We've seen some examples where some monitors have submitted 200 pages of very detailed billing statements delineating who did what work and for how long. And then we've got other billing statements that are just a couple pages long, and they're sending out a monthly fee to the corporation. We don't know what the monitor is doing to earn those fees, and I think that's a very troubling area of this issue for me. So again, I want to thank both of my colleagues from New Jersey for their interest in this and their time, and last of which was their patience in waiting until we got to this panel. I know typically we allow members the courtesy of testifying first, but because Mr. Ashcroft could not stay for the whole hearing period, we did want to give an opportunity for him to testify and members to ask questions. So
would the gentlelady yield?
I will yield briefly to the gentleman. I don't have much time.
I only need to be brief, but I just wanted to say that I agree entirely with your summary of the hearing and what faces this committee. And I think, frankly, Mr. Pallone and Mr. Pascrell have helped us focus on that, and I wanted to thank them as well.
Great. I would like to thank you again for your testimony today, and without objection, members will have 5 legislative days to submit any additional written questions, which we will have forwarded to the witnesses, and ask that you answer as promptly as you can so that they can be made a part of the record. Without objection, the record will remain open for 5 legislative days for the submission of any additional materials. Again, I thank everybody for their time today, and this hearing on the Subcommittee on Commercial and Administrative Law is adjourned.